I call the Committee on Transportation and Infrastructure to order. Today, the committee will consider H.R. 4156, Transparency Airfares Act of 2014, and H.R. 524 to amend the Federal Water Pollution Control Act to clarify that the Administrator of the Environmental Protection Agency does not have the authority to disapprove a permit after it has been issued by the Secretary of the Army under Section 404 of such act. I now recognize Mr. Lobiondo for a motion.
Thank you, Mr. Chairman. Pursuant to the Rule 1A.1 of the Rules of the Committee on Transportation and Infrastructure, I move that the Chairman be authorized to declare recesses during today's markup.
The question is on the motion. All those in favor signify by saying aye.
Aye.
All those opposed signify by saying nay. The opinion of the Chair, the ayes have it, and the motion is agreed to. Our first order of business is to consider H.R. 4156, the Transparent Airfares Act of 2014. I ask unanimous consent to discharge the Subcommittee on Aviation and call up H.R. 4156, and that the bill will be considered as read and open to amendment at any point. Is there an objection? Without an objection, so ordered. Currently, there is a U.S. Department of Transportation rule that prohibits airlines and travel agents from fully revealing the amount of government fees and taxes on commercial airfares. This effectively masks the current government-imposed taxes and fees on consumers. H.R. 4156 allows consumers to see the breakdown of cost that they will pay while flying. For instance, right now, DOT requires an airline and travel agent to advertise a $237 plane ticket as costing $300, hiding the $63 of government taxes and fees from consumers. Further, these government taxes and fees are increased in the proposed White House budget of 2015 by $4.2 billion annually. It is only fair that consumers know what they're paying for. Essentially, all consumer products, whether it's hotels, car rentals, if you're going out to buy a lawnmower today to mow your grass because the weather has changed, you're going to pay more than it's advertised in the newspaper. So essentially, as I said, all consumer products are advertised at base price with taxes added at the point of purchase. H.R. 4156 will let consumers know how much they are paying for their air service and how much they are paying the government in government-imposed fees and taxes. There are some folks that have complained that why are we doing this, because nobody is complaining about it. But if it's hidden, consumers don't know. So we're making sure that consumers know what the federal government is imposing on them in these taxes and fees. This is a good bipartisan bill, and I urge members to support it. I now recognize Subcommittee Chairman Lobiondo to explain the bill.
Thank you, Mr. Chairman. Did a good job with the preliminaries on this, and it is a very good bipartisan bill. And 4156 clarifies that it is not unfair or deceptive practice to display in an advertisement or solicitation the base fare, as long as the taxes, fees, and total cost are clearly separated, disclosed in the advertisement or solicitation. This bill will allow airlines and travel agents to display the actual cost of air travel in a clear and in transparent way, enabling passengers to see the base airfare and the government-imposed taxes and fees. I urge all of my colleagues to support the bipartisan bill, and I yield back the balance of my time.
Do any other members wish to be recognized? Oh, I recognize the ranking member for a statement.
Thank you, Mr. Chairman, and I thank you for bringing this bill to the committee and your leadership thereupon. This bill does a very important thing. It stops the government from playing a shell game with the taxes and fees it imposes on the flying public. Simply put, it restores truth in advertising when it comes to the cost of a flight, finally putting consumers back in the driver's seat. Hiding the real cost of flying from consumers is just plain wrong. Today, Americans demand more disclosure, not less. I am an original co-sponsor of this bill because I do not believe that government-mandated false advertising is the way to go. It is time to give the traveling public better information by restoring airfare advertising rules that worked well for 25 years. The Transparent Airfares Act is a common-sense, bipartisan bill that has broad support from the aviation community, including the International Brotherhood of Teamsters, the Airline Pilots Association, the Association of Flight Attendants, and Airlines for America. I urge my colleagues to support this bill to increase transparency and empower the flying public, and I yield back.
I thank the gentleman. Do other members wish to be recognized on this pending measure? Gentlelady from the district.
Thank you very much, Mr. Chairman. First, I want to say I support this bipartisan bill. The DOT may have thought it was doing the right thing when it said the full price has to be on the ticket, but I think that the bill does it much better with the base pay, with what you pay, plus the taxes, which is what I think most of us are used to and want to understand. Mr. Chairman, I'd like to strike the last word with respect to an amendment I was prepared to offer. I have decided not to offer this amendment, and I very much appreciate my conversations with you and with the ranking member about working with me to deal with the problem that I think already has bipartisan support. Mr. Crawford and I have introduced the same bill, and that's even without knowing that the other was producing a bill or similar bills. And so that means that there's a bipartisan frame of mind on this issue even before the bill comes forward. Essentially, the bill is my amendment would have been about a whole, not in the law, but in law enforcement and detection. It turns out that what you don't know may hurt you. In this case, has hurt women, and that is sexual assaults on commercial airlines, both international and domestic. Now, of course, they are barred. But we have no information about these assaults. Only recently have a few brave women come forward, and I must give credit to the U.S. attorneys who have prosecuted and gotten remedies in those cases. But there appear to be more and more of these assaults. We only know anecdotally, but we do know this: we do not have the information. There's no data that is maintained. We have no insights, and the flight attendants have no guidance as to what to do if one of these assaults is reported. What really amazed me was that these assaults appear not to be regularly reported, and the reason appears to be because they occur perhaps in overnight flights, in the middle of the night, and a woman is assaulted. And anyone who's been on one of these overnight flights with everybody under their version of the covers, apparently these women, according to those who have reported, have been so shocked and afraid that in the middle of the night they have not raised the notion that they've been assaulted. Imagine being on a plane and it's 1 a.m. and you scream out. People are likely to think you're the one that is crazy. So we believe that a fair number of these assaults have gone unreported. We know from those that have been reported that they're so serious that they have been prosecuted. We know that there is no way to get to them now in the systematic way in which we do law enforcement in this country, which is to collect the information and then design a strategy for first preventing and then prosecuting such crimes. These are criminal acts. They are eluding police and prosecutors, and I very much appreciate, since this matter is certainly within the jurisdiction of this committee, that the chairman and the ranking member also see this issue and are willing to work with me and with Mr. Crawford. Thank you very much, Mr. Chairman.
I thank the gentlelady, and we agreed that we're going to work with you moving forward on this. It's a serious issue, and also I'd like to recognize Mr. Crawford.
Thank you, Mr. Chairman, and I thank the gentlelady for working with me, and I appreciate the opportunity to work with her. Our bills are so closely aligned; they'll be so easy to reconcile, and to simply provide a protocol for air carriers to have a way to report, not only to report that, but then subsequent to reporting that we have an enforcement mechanism and we can prosecute and take the appropriate action and adjudicate those offenders. So I appreciate the gentlelady and look forward to working with you on this effort. And yield back.
Any other members wish to be heard? Seeing none, I recognize Chairman LoBiondo for a motion.
Mr. Chairman, I move that H.R. 4156 be approved and reported favorably to the House.
The question is on the motion. All those in favor signify by saying aye. Aye. All those opposed signify by saying nay. The ayes have it, and the motion is agreed to. The bill is approved and reported favorably to the House. Now moving on to H.R. 524. And before we do that, while I have an audience, I would like to, we're going to have a field hearing in the great city of Altoona, Pennsylvania, on April 28th. That, of course, is my district, and I invite all members to travel to central Pennsylvania for that hearing. It'll be on the waters of the U.S. and permitting gas line stream crossings. So, again, I put that card in front of all members. I would encourage you, if you want to come to Altoona and see the hub of transportation in America. Mr. Capuano, don't laugh. It certainly is. It certainly is a great place, and there's great roads that go through there. And many of you probably voted for some of those roads to be funded going here. I, of course, wasn't here at the time, but at any rate, it's April 28th. It'll be a morning. So if you come up Sunday evening, I'll make sure you are treated to Altoona's finest. But again, encourage all members that wish to participate to come travel to Altoona, Pennsylvania. With that, we'll now move on to H.R. 524 to amend the Federal Water Pollution Control Act to clarify that the administrator of the Environmental Protection Agency does not have the authority to disapprove a permit after it has been issued by the Secretary of the Army under Section 404 of such act. I ask unanimous consent to discharge the Subcommittee on Water Resources and Environment and call up H.R. 524 and that the bill be considered as read and open to amendment at any point. Is there an objection? Without objection, so ordered. I recognize Subcommittee Chairman Gibbs to explain the bill.
Thank you, Mr. Chairman, for allowing for this very important piece of legislation to be heard today. The Army Corps of Engineers has the lead responsibility for implementing the wetlands, dredge, or fill permitting under Section 404 of the Clean Water Act. Under the Wetlands Permitting Program, the Corps is responsible for receiving and reviewing Section 404 permit applications and issuing wetland permits. Section 404 assigns the EPA to a limited review role in regard to Section 404 permits. EPA may comment on a particular section of 404 permit applications during the interagency review period for each permit. And EPA also has limited authority under Section 404C to prevent the Corps from issuing a permit to authorize a particular disposal site or to restrict the terms of the permit if EPA determines that the permit would result in certain unacceptable environmental effects. Consistent with this process, in 2007, the Corps issued a Section 404 permit for the Spruce No. 1 mine project in West Virginia. Prior to the issuance of the permit, the project applicant conducted an extensive 10-year environmental review in which EPA fully participated and agreed to all the terms and conditions included in the authorized permit. Subsequently, the mine operation pursuant to and in full compliance with the Section 404 authorization and made substantial investments in the project in reliance on the permit. However, in 2009, the EPA changed the rules of the game after the fact and took steps to revoke parts of the Spruce project's issued permit. More than 3 years after the permit's issuance, EPA finalized the permit revocation in early 2011, effectively halting development of the mine and jeopardizing jobs and the substantial investments that had been made in detrimental reliance on having been issued a 404 permit. After challenging the EPA's permit revocation action in the federal courts, the U.S. Supreme Court announced 2 weeks ago that would not review a 2013 appeals court decision that the EPA did not exceed its power when it stripped Spruce Mine of its 404 permit. Revoking a permit after it has been issued and when no violations of the permit have occurred is unsettling and simply is unfair. It is an arbitrary and irresponsible way for government to act. I consider this regulatory overreach to be a fundamental property rights issue. This is an example of government that thinks it has no limitations of its power. This action by EPA raises the question, what does it really mean to get a permit? What does it mean to get a final decision from the federal government? If an agency is given the right to unilaterally revoke an already issued permit, then nothing can be considered final. The issuance of a federal permit should come with certainty that the activity can go forward unencumbered but within the bounds of the permit, particularly those activities on private lands. This no longer seems to be the case, and it is going to have stifling effect on not just mining operations in Appalachia, but on economic development nationwide. The purpose of H.R. 524 is to clarify that the EPA does not have the authority to disapprove and revoke a permit under the Clean Water Act Section 404 once the Corps of Engineers has issued the permit. This legislation amends Section 404C to authorize EPA to restrict or deny the use of a particular disposal site only until such time as the Corps has issued a permit of such site. This legislation is not an attempt to roll back provisions of the Clean Water Act or eliminate environmental protections. Instead, this bill aims to preserve the finality of a permit by ensuring that EPA cannot unilaterally revoke a permit that has already been issued, and especially one that's not in violation of the permit. I urge all members to support H.R. 524. I yield back.
I thank the gentleman. Now recognize one of the original sponsors of this piece of legislation, the ranking member, Mr. Rahal.
Thank you, Mr. Chairman. Again, I commend you for bringing this legislation to the floor, as well as my colleague from West Virginia, Mr. McKinley, for his sponsorship and leadership on this legislation. Mr. Chairman, while the genesis of this bill lies with the retroactive veto of a duly issued Section 404 clean water permit for the Spruce Mine in West Virginia, located in a district I'm honored to represent, the issue the bill seeks to address transcends this particular situation and indeed transcends coal mining itself. EPA clearly has the authority to veto a pending Section 404 permit and has done so 12 times. However, the Spruce Mine permit, EPA's 13th veto, was the only one to come after a permit had already been issued. Let me emphasize that. The veto came after the permit had already been issued. In fact, it came 4 years later. This is why the Attorneys General from 27 states filed an amicus brief with the U.S. Supreme Court, urging it to review a court ruling that sided with the EPA. In their brief, they took issue with the D.C. Circuit's decision that EPA had the power to veto a permit at any time. They wrote, and I quote, "From coast to coast, highways, bridges, hydroelectric dams, and water reservoirs, just to name a few, are all at increased risk of cancellation by a federal agency that often facilitates with the political winds." End quote. They noted, and I further quote, "The ever-present specter of EPA intervention heightens the fear that a shift in the political winds will make worthless years of planning and spent resources and creates a disincentive to future public investment." And they concluded, and again I'm continuing to quote, "The bottom line is that the D.C. Circuit's decision threatens every ongoing and future public construction project that requires a 404 permit and therefore warrants review. Billions of taxpayer dollars, innumerable work hours and material resources, much needed jobs, and the reliance interest of millions of Americans are now at greater risk." End quote. I would point out that while some of the states who joined us in on this brief were from coal-producing states, the majority were not. Included were the Attorney Generals from states such as Arizona, Arkansas, Florida, yes, Florida, Georgia, Michigan, Missouri, Nevada, South Carolina, and Wisconsin. In ruling against EPA, a lower court accused the agency of resorting to magical thinking in justifying its actions to retroactively veto the Spruce permit. I concur. If allowed to stand, this decision will have a chilling effect on virtually every economic development across the United States. Even if you are a supporter of the EPA, this is a clear case of overreach by a federal agency. I again commend you, Mr. Chairman. I commend the subcommittee chair, Mr. Gibbs, for allowing this bill to move forward, and I urge my colleagues to support its passage and yield back.
I thank the gentleman. Now recognize another original co-sponsor of the legislation, the gentlelady from West Virginia, Ms. Capito.
Thank you, Mr. Chairman. I would like to thank Mr. McKinley for his leadership on this issue, and Mr. Rahal as well as my fellow West Virginians. And I strongly support H.R. 524 because it protects jobs. This bill is, as Mr. Rahal stated in his comments, this is important to all types of industry, West Virginians are familiar with the Spruce Mine case. The Corps of Engineers, in consultation with the EPA, studied the permit for nearly 8 years, and a permit was issued by the Corps, but 4 years later took the unprecedented step of retroactively vetoing the permit. The ramifications of the EPA's actions go far beyond coal and far beyond mining. Permits for fill or dredged material are necessary for any number of economic activities, whether it's construction or agriculture, anything for economic development where there's a large moving of the earth. EPA's retroactive veto of the Spruce Mines permit sets that precedent that no permit is ever final. When a permit is issued for a new building, a new highway, or a new factory, no one can ever be sure if it will remain in force. Such regulatory uncertainty will have a chilling effect on the investment and also make it harder to grow jobs in this country. It's important to understand how the Clean Water Act is supposed to work. Congress granted the Corps of Engineers the authority to issue permits for the discharge of dredged or fill material. Other types of discharges are regulated by state governments in most states. While the EPA has an important role to play, including the authority prior to the issuance of a permit to reject areas where materials may be discharged, the Corps of Engineers is the permitting authority for dredge and fill permits. EPA's interpretation of the Clean Water Act, which has now been backed by the U.S. Court of Appeals and the District Circuit, gives the agency sweeping power to take away a permit anytime it wants and really makes a mockery, I believe, of the primary authority that Congress gave to the Corps of Engineers under Section 404. Of course, there should be strong environmental safeguards in the Clean Water Act, and of course a company should be required to comply with the permit's terms. West Virginians were given a stark reminder of the importance of common sense regulation earlier this year when a chemical spill at Freedom Industries in my district caused 300,000 people to lose access to clean water. We need environmental standards and enforcement in order to protect our drinking water. That's why the Clean Water Act involves multiple agencies, including the Corps, the EPA, and state agencies in the review process. The Corps has the authority to modify, suspend, or withdraw a permit if circumstances change, or if a company fails to comply with the permit. In the Spruce case, the EPA asked the Corps of Engineers to withdraw the permit, but the Corps of Engineers declined. In retroactively vetoing a permit, the EPA did not correctly apply the Clean Water Act, and the committee is here to correct that problem. By passing today's legislation, we are saying very simply that once a permit is issued, a company receiving it should be allowed and ready to invest in their facilities and hire workers without the fear that changing winds in Washington will eviscerate their permit. If this bill were solely about correcting the EPA's flawed interpretation of the Clean Water Act that marginalizes the regulatory authority granted by Congress to the Corps, it would be important legislation in order to protect the constitutional prerogatives of the legislative branch. If this bill were about providing the regulatory certainty that is critical to our job-creating industries, it would be critical to support the bill, especially in a time when our economic recovery is so weak. But this bill is all the more crucial because of its impact on the lives of real people and real families. The Spruce Mines was set to employ over 250 West Virginia workers. Those jobs were snatched away by the administration's decision to issue this retroactive veto. Congress cannot let the EPA's expansion of its own authority go unanswered while the jobs of still more American workers hang in the balance. Examples of the EPA's overreach abound in southern West Virginia. Just before coming to this markup, I met with a group of West Virginians committed to building the King Coal Highway. This project, it's in Mr. Rahall's district, is a public-private partnership between the state of West Virginia, two coal companies that would allow for mining and also lay the groundwork for a 4-lane highway. This would save the taxpayers $110 million in highway construction costs, yet the EPA has stood in the way. It's time for Congress to make abundantly clear the proper role of the EPA in the clean water permitting process. H.R. 524 simply makes that clear that Section 404 of the Clean Water Act should apply in the same way that administrations of both political parties have applied it for nearly 40 years before the Spruce case. EPA will have veto authority while an application is being considered, but only the Corps has jurisdiction over a permit after it is issued. Today's legislation is a good common sense step. in fighting the EPA's overreach and protecting jobs, and I urge my colleagues to vote for this bill.
I thank the gentlelady, and with that, do any other members wish to seek recognition? Mr. Garamendi.
Thank you, Mr. Chairman. I note that this has arrived at the committee for final markup without a hearing. This bill is the result of an extremely controversial project, mountaintop removal project. That controversy had gone on for many, many years. The courts of the land have already ruled on this case and apparently heard many of the merits, although this committee has not heard, at least in a hearing, the merits of this issue. I do note that there is substantial opposition to the bill. I note American Rivers, the Clean Water Action, Earth Justice, Environment America, the League of Conservation Voters, the Natural Resource Defense Council, Sierra Club, Southern Environmental Law Center, National Parks Conservation Association, and Trout Unlimited have concerns and are opposed to the passage of this bill at this time. I would also seek permission to enter into the record a letter from the Trout Unlimited organization. Perhaps there's opposition to that being entered into the record. If not, I would so seek that permission. The point here is that this would be the 14th time over the history of the Clean Water Act that a veto under Section 404C has occurred. This one somewhat different after a permit had been granted. However, it should be noted that there was controversy and an effort by the EPA to have the Corps itself pull back the permit because of the controversy and the environmental issues surrounding this particular project. Given that, the EPA was left with no option but to revoke the permit based upon Section 404C. The court handled this case. The court heard the case and said that it was within the scope of the law to act and to issue the revocation. I don't know at this point, given the extraordinary controversy surrounding this particular case and this bill, that it would be in the best interest of this committee and the House and the environment of this nation to to move forward with this bill. And I'm concerned about it, and I'm going to ask for a roll call vote. And I yield back my time.
Thank you, gentlemen. I think the gentleman requested to have something entered into the record. Is that correct? Mr. Garamendi, did you request to have something entered into the record? I missed that.
I did. A
okay.
letter from Trout Unlimited.
Without objection, so ordered.
Thank you.
Now recognize Mr. Nadler.
Yes, Mr. Chairman, I will join Mr. Garamendi in opposing the bill. The EPA, this law has existed. The EPA is for, 44 years now. This revocation of a 404 permit has occurred, I think Mr. Garamendi said 14 times in 44 years. It's an extraordinary event. The standards for Section 404 permit by the Army Corps of Engineers are different than the standards for protecting the environment, which is the purview and the mandate of the EPA. 14 times in 44 years, one of them, at least one of them, the one that we were talking about being very controversial, is not an overuse of power, is not an agency swinging its weight. We do not know in this committee, and as the gentleman from California said, there were no hearings, no markup in subcommittee so far as I know, but certainly no hearings. We don't know the circumstances. I don't know that the case has been established to show an abuse of power by the EPA, why this power, which has been very sparingly exercised, should be taken away. It may be, very much so may be, we haven't had the hearings to show that it is not the case, that it was essential to protect the environment that this permit or these 14 permits over 44 years be revoked. And until we see a very good reason why the EPA shouldn't have this power, why it should, to see that it's been abused, I don't see why we should come in now and say that the EPA can't do this and revoke this power to protect the environment, which has been very sparingly used over 44 years. Now, the EPA's power is, like the power of all administrative agencies, subject to court review on an arbitrary and capricious standard. Apparently, the Circuit Court of Appeals decided, A, they had the power, B, they had not exercised it arbitrarily or capriciously, and so with no real knowledge of the situation, we're going to come in and say no. But we're not going to come in and say no to affect this case, because as I understand it, this bill is prospective only. So to prevent a rare but perhaps crucial exercise of discretion by the EPA, rare enough it's been 14 times in 44 years, in the future, we're going to change the power of the EPA in a way that could prove very damaging to the environment or not. We have not held hearings. We don't know what we're doing. We're flying blind. We should not approve this bill under these circumstances. So I urge my colleagues to oppose this bill. I yield back.
I thank the gentleman. I believe Mr. Gibbs is seeking recognition.
Right. Thank you, Mr. Chairman. First of all, I want to make it clear that the subcommittee did have hearings on this, and it was the last Congress, not this Congress, because this last year we were tied up with WRDA. This bill doesn't affect the outcome of Spruce Mine. It's not retroactive. It's going forward. And I think what's important to make clear, some of the comments have been made, that the EPA should have the ability to step in. And the EPA does during the application process of the permit. The difference is there's nothing in the Clean Water Act that gives them the authority to revoke a permit after the permit's been issued if the operator is not in violation of the permit. In the case of Spruce Mine, it sets a very dangerous precedent because they were not in violation of the permit. And it doesn't matter how you might feel about mountain type mining, any of that. This sets a very dangerous precedent because lots of businesses, lots of entities in this country have to have a permit from the government to be in business. And you know, when you have you get your permit and you're operating under the permit in good faith and lawfully, and a bureaucrat or an agency can come in and revoke that permit, take it away from you, that's going to stifle economic activities, because who's going to risk capital and borrow money knowing that the government can step in and take it away even though you're not in violation? That's the difference that people aren't putting together. You know, when you got the permit going through the process, the EPA can't step into the court and say, no, we don't like this, we're going to veto that, and the permit applicant knows that. But after you get the permit and they come in years later and do it, and you're not in violation of the permit, there's something un-American about that. And that's what this issue is about. So it's moving forward to provide certainty to the business community out here that if they get a permit and they're operating under the permit requirements, that they will be able to stay in business. I yield back.
Any other members wish to be here recognized? Mr. Nolan.
Mr. Chairman, I think the issue has been addressed, but I just want to ask two questions of the sponsor. Number one is, just to clarify, at any point in the process before the permit is issued, the EPA can step in and deny it. I'd like an affirmative answer to that. And then secondly, should the circumstances warrant a reconsideration at some later date, does the Army Corps still have the authority to step in and withdraw or reconsider the permit?
Mr. Gibbs.
They have the ability during the application process to revoke the permit. I'm not ready to veto the permit, use the right word. And if an entity that has the permit is in violation of the permit, obviously the Corps of the EPA would have the right to step in and try to correct the violations first, I would say. And if they don't, I think they would have the ability to step in and revoke the permit. But the difference here is they revoked the permit and they weren't in violation of the permit. That's a big difference, and that's what we need to remember.
Yeah. But further clarification, let's suppose they're not in violation of the permit, but new knowledge, new information has come to light. Would the Army Corps still have the authority to do a reconsideration as opposed to the EPA?
Directed to staff, he can answer and technically.
To answer that question, if new information comes to light, to some extent it'll depend upon this. Let me get a little closer. Can you hear better now? Okay. If new light comes to, new information comes to light regarding a permit what I think you're getting at is raising a question as to the completeness of the application. If it was information that just happened to become available later on, to my knowledge, there has never been a situation of actually going back and, say, revoking a permit. There could be the potential for reopening a permit for further consideration in those sorts of circumstances if there are material changes in, say, the nature of the operation. But the point of having a permit application process in the first place is to make sure that you have a complete record to be able to judge the project upon in the first place, and then to be able to make a decision on that and go forward and stand by that decision until the possibility of the next time that a permit may come up for renewal.
Mr. Chairman, just one brief question so I understand this. Of course, it's nice to know everything that there is to know about something, but the nature of discovery and technology and humankind is we frequently don't. And so what you are saying, that if new knowledge came to light, that there still would be a procedure available for requesting a reapplication and a reconsideration through the Army Corps' permit process?
Well, usually it's in the context of if there's a material change in the, let's say, the proposed nature of the project.
Let's say we discovered a pollutant that we didn't know about and it was having some harmful effects. Are we in a situation, if say we pass this legislation, it says the EPA cannot go in and withdraw that, would the Army Corps still, would someone have a way or a vehicle to ask for reconsideration of this?
There is the potential for a reopening of a permit if there are material changes to the permit situation.
Okay, so there is a way to deal with that in those kind of circumstances.
That's right.
Okay.
But it would have to be a material.
Yeah. All right. Thank you, Mr. Chairman.
What were you getting at?
Gentleman's time has expired. We're going to now consider the bill for amendment. Are there any amendments?
Right.
Seeing no amendments, I ask Mr. Gibbs for a motion.
Mr. Chairman, I move that H.R. 524 be approved and reported favorably to the House.
Question is on the motion. All those in favor signify by saying aye. Aye. All those opposed signify by saying nay. The ayes have it. The motion is agreed to. The bill is approved for order. Report favorably to the House.
Mr. Chairman, I'd ask for a roll call vote.
A roll call vote has been requested. A sufficient number of members have requested a recorded vote, and pursuant to Rule 5E of the Rules of the Committee on Transportation and Infrastructure, a recorded vote is ordered. The clerk will call the roll on final passage of the bill.
Mr. Schuster.
Yes.
Mr. Schuster votes yes. Mr. Rahal.
Yes.
Mr. Rahal votes yes. Mr. Young.
Yes.
Mr. Young votes yes. Mr. DeFazio. Mr. Petri.
Yes.
Mr. Petri votes yes. Ms. Norton. Mr. Coble.
Yes.
Mr. Coble votes yes. Mr. Nadler. Mr. Duncan. Mr. Duncan votes aye. Ms. Brown. Ms. Brown votes no. Mr. Micah. Ms. Johnson. Mr. Lobiondo. Mr. Lobiondo votes aye. Mr. Cummings. Mr. Miller. Mr. Miller votes aye. Mr. Larson. Mr. Larson votes no. Mr. Graves. Mr. Graves votes aye. Mr. Capuano. Mr. Capuano votes no. Mrs. Capito. Mrs. Capito votes aye. Mr. Bishop. Mrs. Miller. Mrs. Miller votes yes. Mr. Michaud. Mr. Michaud votes no. Mr. Hunter. Mrs. Napolitano.
No.
Mrs. Napolitano votes no. Mr. Crawford. Mr. Crawford votes aye. Mr. Lipinski. Mr. Lipinski votes no. Mr. Barletta. Mr. Barletta votes yes. Mr. Walls. Mr. Walls votes no. Mr. Farenthold. Mr. Cohen. Dr. Bouchon. Dr. Bouchon votes yes. Mr. Sears. Mr. Gibbs. Mr. Gibbs votes aye. Ms. Edwards. Ms. Edwards votes no. Mr. Meehan. Mr. Meehan votes aye. Mr. Garamendi. Mr. Garamendi votes no. Mr. Hanna. Mr. Hanna votes aye. Mr. Carson. Mr. Carson votes aye. Mr. Webster. Mr. Webster votes yea. Ms. Hahn.
No.
Ms. Hahn votes no. Mr. Sutherland. Mr. Sutherland votes yes. Mr. Nolan.
Aye.
Mr. Nolan votes aye. Mr. Denham. Mr. Denham votes aye. Mrs. Kirkpatrick.
No.
Mrs. Kirkpatrick votes no. Mr. Ribble. Mr. Ribble votes aye. Ms. Titus.
No.
Ms. Titus votes no. Mr. Massey. Mr. Massey votes aye. Mr. Maloney.
No.
Mr. Maloney votes no. Mr. Daines. Mr. Daines votes yes. Ms. Esty. Ms. Esty votes no. Mr. Rice. Mr. Rice votes yes. Ms. Frankel. Ms. Frankel votes no. Mr. Mullen. Mr. Mullen votes yes. Mrs. Bustos. Mrs. Bustos votes aye. Mr. Williams. Mr. Meadows. Mr. Meadows votes yes. Mr. Perry. Mr. Davis. Mr. Davis votes yes. Mr. Sanford. Mr. Sanford votes aye. Mr. Jolly. Mr. Jolly votes aye.
I'll get called in just for the vote. I'll get called in for the vote. Unbelievable.
Do any other members wish to be recorded? Mr. Hunter, how is Mr. Hunter recorded?
Mr. Hunter is not recorded. Mr. Hunter
Do
votes
any other
aye.
members? Mr. Bishop, how's he?
Mr. Micah is not recorded.
Mr. Micah, how do you wish to be recorded?
Mr. Micah
Mr.
votes
Bishop
aye.
is requesting his vote.
Mr. Bishop votes no.
Mr. Chairman, I'm not recorded. I want to be recorded as a no.
Gentleman from New Jersey?
No.
Gentleman
Mr.
from New York?
Sears?
No.
Gentleman from New York, Mr. Nadler? No. Any other members wish to be recorded? Ms. Norton?
Voted no.
Any other members wish to? Mr. Cummings?
Mr. Cummings? Mr. Cummings votes no.
Any other members wish to be recorded? Seeing. Gentlemen. How's Mr. Nadler recorded?
Mr. Nadler is recorded as no.
No. I thank the gentleman. All members cast their vote. The clerk will report the vote.
On this vote, the ayes are 34, the nays are 19.
The bill is agreed to. The bill is agreed to. And with that, before we move on, also for members who weren't here, I'd like to cordially invite you to Altoona, Pennsylvania on April 28th for a hearing, full committee hearing on the waters of the U.S. and permitting gas lines and stream crossings. It'll be Monday morning, and you come to Altoona. We'll treat you to all the hospitality that we can possibly muster in Altoona, Pennsylvania, which is a lot. So again, that's April 28th in Altoona, Pennsylvania. And also, I'd like to take this opportunity to welcome our newest member to the committee. Congressman David Jolly was elected to represent Florida's 13th congressional district. Let's give the gentleman respect. He's now serving on the committee. I'd like to introduce him to all of you. Mr. Jolly was elected to the 13th Congressional District during a special election to finish the term of the late Congressman Bill Young in the 113th Congress. Congressman Jolly served as Vice President of Clearwater-based Boston Finance Group, a specialty finance and private equity company investing in job-creating businesses, as Chief Executive Officer of Olympus Foundation Management, a Clearwater-based professional services company supporting life cycle philanthropy of nonprofits and individuals. Prior to that, Congressman Jolly created and owned multiple businesses, including a communications firm, a law firm, and a consulting firm. Congressman Jolly began working for Florida's 10th Congressional District in the House of Representatives in 1995 as a congressional staffer until 2007. Congressman Jolly received his Bachelor of Arts in History from Emory University in Atlanta. He then studied in the evenings to earn a law degree from George Mason University of Law in Arlington, Virginia. Mr. Jolly, welcome to the committee, and we'll yield you if you have a few words. Let me committee come to order so Mr. Jolly can say a few words.
Mr. Chairman, no real comments other than I look forward to working with each and everybody on the committee, and I appreciate your assistance thus far.
Thank you, Mr. Jolly. Appreciate it. Welcome to the committee. Mr. Rahal.
Mr. Chairman, on behalf of the minority, we welcome the gentleman from Florida as well to the committee, and I know he has some big shoes to fill, but very capable of doing that. Appreciate it.
I thank the gentleman, and with that, did I mention Altoona, Pennsylvania on April 28th at 9 o'clock in the morning? I think, well, thank you, Mr. Rahal, for reminding me of that. I ask unanimous consent that each bill ordered reported today will be reported as a single amendment in the nature of a substitute, incorporating any amendments adopted without objection. So ordered. I ask unanimous consent that the staff be authorized to make all necessary technical, clarifying, and conforming changes to each of the bills ordered reported today to reflect the actions of the committee without objection. So ordered. I ask unanimous consent that the chairman, after consultation with the ranking member, have authority to strike or revise any provisions of any of the bills ordered reported today that would cause a sequential referral to another committee, or that it would cause the bill to be subject to a Budget Act or Rule 21 cut-go point of order. Without objection, so ordered. Pursuant to Clause 1 of Rule 22, I ask unanimous consent that the committee authorize the chairman or his designee to offer such motions as may be necessary in the House to go to conference with the Senate on the following bills that were ordered reported by the committee today, or similar Senate bills: H.R. 4156 and H.R. 524. Without objection, so ordered. Pursuant to Rule 5 of the Rules on the Committee of Transportation and Infrastructure, and the chair notes the presence of a quorum for actions taken on all the committee business today. With the Committee on Transportation and Infrastructure has completed its business for today, and the committee now stands adjourned.